Yo, my bad, y'all. I was listening to some clubhouse shit. I almost slipped the time, man. I almost slipped the time. Um, yeah, that was on me. Um, what's good though? Tap in, tap in. You already know what time it is. We gon' hold on. I'm gonna try to goddamn phone be tripping so motherfucking much. It's kind of brazy how this shit be tripping. Motherfucker do what the hell I want to do, but we're gonna try to get on here and get to what we was talking about, what we left on the tag, on the initial video or whatever. Just we get on thug this shit, man. This shit getting braided and braided. But I'm gonna tell you something though. Blood gonna get back on the pill. They're gonna probably end up throwing this conviction out. It's just too much braided shit going on with that. They locked his lawyer up. They have secret meetings with witnesses behind the scenes and all type of shit. So honestly, I think they're gonna end up probably throwing this conviction out overall. That's what I think. I don't know how true it's gonna be, but I think they're gonna end up throwing this conviction out and probably end up letting him go straight home. Um, Georgia, one of them states, man, they still want niggas in chains, so they're gonna do whatever they're gonna do whatever they can to try to keep him in jail. That's the reason why they won't get a young and no bail and shit. So, but that's just my opinion. There's so many hiccups in their case that he got so many grounds to appeal. I don't think they're gonna. I really don't think it's they're gonna be able to hold this conviction up in court. So, but we gonna get into it. Um, I didn't know that was man. I mean the man been in jail for like um what close to 2 years now, and he still ain't got no bond or whatever. He got so many codified. He got someone for testified on that case. So I don't think they're gonna. I think overall, I think they're gonna end up throwing this conviction out. Just because I had a lot of homeboys that been in prison, with the trial and all that. So that's just my thing. I think they're gonna end up throwing this shit out. But hold on, let me see. My phone be tripping so much for the hard. These goddamn androids, man. Crapping and screaming. This bitch start doing what it want to do. So we want we're gonna get into the content. Yeah, I was not listening to this clubhouse shit. They talking about this hot ass female here, man. She told everybody. That nigga blood be tripping though. Um, so we're gonna get to it. Hold up. Yeah, but like I said, I think and overall I think they're gonna end up throwing this case out. He's gonna end up going back on appeal. And I think they're gonna end up throwing this case out and shit. And I think this one they hold his lawyer in contempt or whatever. Um, hold on. Go back here so I can bring it up. Shout out to Red Circle for me to be able to do this. Mm. Give me 1 second. Let me fix this so I can get this thing popped up.
And as a part of your capacity as the general manager, would you oversee them directly, or was there someone beneath you to directly supervise them?
So as a general manager, I have.
All right, Sergeant Ingram, all our jurors present, sir.
Yes, sir.
All right. Yes, sir.
Good morning, Your Honor. Good morning, everyone. Your Honor and everyone, with the court's permission, the Sheriff's Office approved it. Sitting to my right is Jack Pines, P-I-N-E-S. He is a rising second year law student at Georgia State University.
Are you charging for these like experiences, Mr. Steele? Like you're cycling through a whole bunch of people, you know?
Take them all. They're great lawyers to come to.
No, it's free labor, okay, sir? Subsidized labor. What, Mr. Pines? Good morning, sir. Good morning. Yes, he's welcome to be here.
No, wait a
All
minute.
right. Anything else?
Constant. Hold on.
Okay, anything else before I call for our jurors? Oh, good morning, Ms. Hollinger. Good morning. And where's Mr. Kokomo? Good morning. All right, good morning. Where's Miss Knight? Did y'all let her go or something like that? All right, okay, all right. Some of our jurors, please, sir.
Look at Thugger. Down, Thugger.
All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. All right, ladies and gentlemen, jury, good morning. Morning. All right, without further ado, all right, state, call your next witness.
Good morning, Your Honor. At this time, the state calls to the stand Mr. Ira Singleton.
All right, summon Mr. Singleton, please.
That nigga fighting for his
Mr.
life.
Singleton, good morning, sir. Sir, if you would please approach the witness stand. Once you get there, if you'd be so kind and turn and face Sergeant Ingram, be sworn as a witness before you sit down, sir.
Raise your right hand. So I affirm testimony you give the truth, the whole truth, and the truth.
I do.
You know, man. I follow, subscribe.
Ira Singleton, IRASINGLETON.
Good morning, Mr. Singleton.
Morning. I'm sorry?
Where are you from?
Originally South Carolina.
Okay. And do you currently live in the Metro Atlanta area?
I do.
When did you move to the Metro Atlanta area?
Back in 2003.
And have you resided here for the major portion of your time since relocating?
Yes.
Okay. And what is your educational background?
I attended Coastal Carolina University. Graduated in '94 with a business degree.
Okay. And where's Coastal Carolina University?
Conway, Myrtle Beach, South Carolina area.
Can you hear me right now?
Can you hear me? Okay. All right. What do you do for work?
Currently,
Yes, sir.
District manager for Town Park.
Okay. And have you always worked for Town Park?
No,
What did you do before that?
I was with Hertz Rent a Car.
And how long did you work with? Well, let me ask you this: how long have you worked in the capacity with Town Park?
This motherfucker, they run.
Started with them, I think, in 22.
Okay.
Damn.
To the present?
Yes.
Okay. And when you were with Hertz, how long had you worked with Hertz?
From October 94 until I think it was June or July of 21.
And what kind of work did you do at Hertz?
So when I left Hertz, I was the general manager at the Atlanta Hartsfield Airport.
And what was your first role when you arrived to Hertz?
First role?
Yes, sir.
I started out at Hertz in Myrtle Beach as a kind of sales agent, so I rented cars.
Okay.
I did that for a couple months.
Okay. And you said you did that for a couple of months. Did something change after a couple of months?
I was promoted.
Okay.
So yeah, I kind of moved up through the ranks.
Okay.
Became a manager, and that's how my career started.
All right. And how long did you work at the Atlanta Hartsfield Jackson Airport location of Hertz Rental Car?
So I transferred here in 2003. And then I was promoted again and transferred to work the Alabama market.
Okay.
That would have been 2009. And then I returned to Atlanta in another capacity back in 2000, I want to say 14.
Okay. Right.
We're gonna give y'all
And how many years total did you work for Hertz?
we're gonna go to Woody.
About 26 and a half years.
Okay.
They actually we're gonna go to the joint where they try to lower it.
What were your duties and responsibilities in your capacity as the general manager at the Atlanta Hartsfield Hertz Rental Car Airport?
They're going for like 4.
Atlanta Hartsfield Jackson location of Hertz Rental Car.
Basically the P&Ls,
like
overall service, sales, and just growth of the business.
Okay. When you say P&R, what is that?
P&L.
P&L. excuse me.
Just your income statement, profit and losses.
Damn.
Okay.
Sorry.
They like
No
these
problem.
niggas, man. I fed all these niggas, man. They burning me, man.
As a part of your duties, would you also oversee the day-to-day business of the business?
Absolutely, yes.
Did that include supervising other employees?
Yes.
Okay. About how many employees would you have under your supervision in 2015? Say.
32, so you'd be all right.
I would say it was over 400, close to 500.
The paperwork though. Ooh, we got a lot of paperwork. I'm going through his case for like 3 years. Going through the paperwork on this case.
And as a part of your capacity as the general manager, would you oversee them directly, or was there someone beneath you to directly supervise them?
Are we going to testify?
So as a general manager, I had 2 assistant GMs.
Okay.
And under them, you had different levels of managers. So it was a total of 30 managers, I think, somewhere around that number.
2 assistant general managers?
Correct.
Okay. And
now, you talking 15 or you talking now?
Oh, in 2015.
Oh, 2015, I was in a different capacity. I was, I don't remember what the title was, but it was like director of operations.
Oh, okay.
So, yeah. So I reported to the general manager then.
I see.
Yeah. And so those managers, yeah, they were the level under me.
Okay. All right. And in as a part of your role and responsibilities as the director of operations, Well, let me ask you this. How long do you remember serving in that capacity?
That would have been when I returned from Alabama until, I want to say 2019, maybe late 18.
Okay. Do job titles at Hertz change frequently to your knowledge?
Of course.
Okay. Why is that?
Anytime there's leadership change, the new leader, depending on where they come from, what their background is, they would change titles. At one point, I was a city operations manager, then I became a director of this, a director of that. So yeah, it always changed.
And in those changes of the job titles that you described, were there just name changes, or did your duties change as a part of those job titles?
Just name change.
Okay. So is it fair to say that your duties and responsibilities as the director of operations were the same as when you were general manager?
No.
Okay. What difference did you have in duties as director of operations versus when you were the general manager?
So general manager, you're like the head of everything.
Okay.
And as a general manager, you will have directors that report up to you.
Right.
And as director of operations, what distinction did you have as what distinction between director of operations? What were your duties and responsibilities as that?
Right. Whatever the key points of interest are, that's what you're responsible for. So with operations, you have what we call the front of the house business, and you have the back of the house. The front of the house would be anything dealing customer facing. Back of the house would be anything that's dealing with cleaning cars or servicing vehicles, maintenance side of it, this maintenance side of the business. All of that would be what we call back of the house.
Okay. You say KPIs. Do you know what kind of things you would be focusing on as a KPI? Key points of interest?
Of course. Sales.
Okay.
Service levels.
This nigga got about 2-3.
Growth.
This nigga got 2 little man.
Those are the main ones.
Okay. All right. What does it mean to be a gold member or gold customer at Hertz?
So gold is a service that you anyone can sign up for. If you're someone who rent often, it's an expedited service, whereas a regular customer will have to come in and rent by qualifying at the counter with a driver's license and a credit card. As a gold member, you would come in, select a car. Once you get to the exit, they would verify who you are and expedited service.
Okay. All right. And if you're not a gold member, then is there a name or a designation for someone who's not a gold customer?
Just regular customer.
Okay.
Yeah. So we had like several tiers.
Okay.
Yeah.
What is a walk-up renter, if you will?
So a walk-up renter would be someone, let's say anyone in this room now who wanted to rent a car. You could just basically go to Hertz, Avis, wherever, and just walk up and, rent a car.
Okay. Is there a different location for, if I were a gold member, that I would go to at Hertz than opposed if I wasn't a gold member to pick up my vehicle?
Yes.
Where is that location?
At the airport?
Yes, it's at the Atlanta airport.
So on the third level, if let's say you were flying in as a inbound flight, you were coming in, you caught the Sky Train to the rental car center. You would take the escalators down to level 3. And at level 3, you'll find the main Hertz counter. That's where all the, regular would be processed. When you go through the double doors and you cross the bridge, that area, what we call our VIP booth, it's a booth separate from the main counter. That's where your different tiers of gold would be serviced.
Okay. And I want to talk about what you mentioned earlier in portion to circle back to what you said about the process. So with respect to the process of renting, Can you describe how a Gold Club member would know which vehicle was assigned to them if they just walk up to this counter?
Are we talking now or
in 2015? My questions are centered for 2015.
Yes, it's totally different ballgame now.
Okay.
Everything's changed
Yes, sir.
with technology. But back in 15, we had what we call Voltron boards. So similar to, so if I booked a reservation as a Gold member and I arrived at Hertz, once I get to what we call the Gold area where the Gold VIP booth is, if you look to the left, there's 5 panels of boards and it'll look for your name. So your name will be up and it'll tell you what space number your car is parked in. But everything, and that was the benefit of Gold, is that you didn't have to go stand in lines. It's just an expedited service, whereas you can come in, you can see Ira Singleton on the board. It'll say stall 535. You go to 535, load your car, and you go to the exit gate, and that's where your rental is processed. And there really, as a Gold, they would just basically verify with driver's license that you are who you are.
And when you say they, who are you speaking about?
I'm sorry. They would be the exit gate representatives.
Okay. How many gates or locations, or let me ask a better question. Are there checkpoints at Hertz?
What do you mean?
Security checkpoints.
We have exit gates.
Okay.
The exit gates would be reps. So exit gate reps. Okay.
And before I get into that, I want to circle back to something you said. You indicated there was a Voltron board, correct? After a person has identified where their vehicle that they have rented is located on that board, would they have to interact with any representatives at that time?
So no, but let's say I'm in space 535, all right? I'm a tall guy and I get there and it's a Toyota Corolla, right? So at that point, for me to switch that Corolla into something that would be more suitable for my size,
We got the
I would have to go inside and see someone, yes.
Okay. They won't thugger.
How does a Gold Club member initially make a reservation if they don't interact with anybody to begin with?
Everything's web-based. Okay. So you can go online and you can book a reservation through hertz.com.
And as a part of that booking process for a Gold Club member, would you have to enter any personal identifiable information on the web?
As a Gold Club member?
Yes, sir.
Already stored.
Okay. Would you have to provide driver's license on the web and credit card information on the web?
That is Gold, no.
Okay. What point, if you provide such details and information for the reservation to be complete?
When you exit.
Okay. All right. And I want to circle back to the overall process as it relates to picking back up the vehicle. So you stated earlier that a vehicle would be in a particular space. When a Gold Club member would go to pick up their vehicle, would the keys already be in the car?
Yes.
Would a rental contract or documentation already be in the car pertaining to that person?
In 2015, yes.
Okay.
Yeah, I was a Gold member at Hertz. Yep. You ain't lying.
Okay. Would a so earlier you described you made mention of the front of the business. Is the front of the business located inside of the airport?
So when I say front of the business, in that term, that means anything customer facing. So anything that involves a customer, that's what I mean by that.
Okay. As it relates to the process that you described you kind of touched on as it relates to persons who are not Gold Club members, what does that process look like for a person? You can answer the question.
Repeat your question.
Sure thing. What does the booking process entail for a person who is not a Gold Club member?
Okay, so if I was to go online and book a reservation, I would have to go through the process of selecting a car that I want to drive. And to complete the booking, you would have to put in a driver's license and a credit card as a regular customer.
Mm-hmm.
Okay. And with that card information and driver's license information as a regular Hertz renter, at any point during the pickup process be verified?
Absolutely, yes.
When would that particular portion of the verification process occur?
My video.
So that would occur at the start of the rental process. So once you approach the counter as an agent, I would introduce myself and then ask you for your driver's license and your credit card.
Okay.
So it has to be can't be a debit card.
Do you know a
credit card.
Mr. Richard Alivor?
Yes.
And would you know what part of the business he would have been working? Where do you know him from?
Hertz.
Okay. Mm-hmm. And was there ever a time that you all worked together or he worked under you?
Absolutely, yes.
Would you have known where he was working in 2015? Inside of Hertz, that is?
He was, back then, he was a gold agent. So he would work the gold VIP desk. That's where he was most of the time. Now, if he was working overtime, he possibly could be picking up a shift at the main counter. But in 15, Richard was a gold rep.
Okay. Mm-hmm. And was he under your direct supervision?
In 15, not direct. He had another manager that he reported to, and that manager reported to me.
Okay. Now, I want to go back to what you were describing about vehicles being available for pickup based on what's printed on the board. Do you recall that part of your testimony?
Yes.
Okay. Can anyone just simply walk up and take a vehicle without having to go through any security checkpoint, simply because the keys are in the car and the rental contract is in the car?
That would be called theft.
Right.
But could they, based on the security checkpoints you described earlier, just come up and take a car and leave?
That's theft.
I don't know how to answer that one.
Okay.
This is Atlanta. It happened all the time.
Okay. All right. Let me ask you this. As a part of Hertz security gate that you described at the end,
okay,
are they supposed to check with a representative before clearing that threshold?
Yes. So any customer that rented a car will have to exit the main exits, and it's 5 exits.
Okay.
And at any given time, depending on what day, we would have, back in 15, 5 people at each one of the exit gates. There was also a service exit, which only employees were able to exit the service exit.
Okay. Whether I was a gold member or whether I was a regular walk-up member, Hertz renter.
Yes.
Would Hertz always confirm? Was it the policy or the procedure of Hertz to confirm that the driver's license identification and the person inside the vehicle were the same prior to leaving through the exit gate?
Wow.
You can't answer that question.
That's okay.
Regular customer, gold customer?
Either. Let's start with the gold customer first.
Okay. Gold customer, driver's license.
Okay.
Because everything's on file.
Okay.
So as a gold member, currently, my credit card, my driver's license is on file. When I rent a car now as a non-Hertz employee, I have to qualify when I leave the exit gate. So when I get there, now it's different, whereas everything is on your phone. And you know where to go. When you pick up your car, you go to the exit, they're going to ask you for your driver's license, and they verify your driver's license. They scan the car and they match everything. Back in 15, it was different because everything was a paper contract. And so that paper contract would say Ira Singleton. When I got to the exit as a Go customer, I would present my driver's license. And that's how they would verify that I am who I am.
Okay.
And verify that I'm in the right vehicle.
Understood.
Mhm.
Now, as it related to the process for someone who's not a Gold Club member, would you, in fact, would the back gate representatives, as you described, use your words, have to verify their identity prior to that vehicle being released through that gate as well?
So back in 15, everything was done on the front end. So the rental process, you approach the counter, I receive the driver's license and your credit card, right? I have to verify that the license and the credit card match, right? So basically, I can't rent a car with Mr. Brown's credit card. So that's what I have to verify. That's procedure. And once that's verified, that's called, basically qualifying whoever's trying to rent a car to rent. Once that's done, then I would take them through the process, meaning we would go through all the questions that you would ask. Once everything was done, we would run the credit card for authorization for whatever the rental charges would be, plus whatever the incidental charge was back during that time. And then you would sign. So we would get a mag signature from you. I would return your driver's license and your credit card. You would go outside. I would tell you where the car's at. You would grab your car, and then you would go to the exit gate.
We're gonna stop this one,
right? One of the 5.
and because this is supposed to be the guy that they rented the car from. I was supposed to have hit nut, so we're gonna go to Woody's testimony. I know that's what everybody wanna go to. So we're gonna go to Woody's testimony. The testimony is 20 minutes. We're gonna go here. They keep taking my shit off of Instagram. They keep stopping my Instagram. So we're gonna go to Woody's testimony now. So they keep stopping our video. So the Hertz vehicle front.
I'm Olivia K of Olivia K and the Partners. I don't want anyone who's a fan of our music.
Then we're gonna go to
Published once it's submitted with the course ruling.
This is Woody testimony. Now he went and pleaded the 5th on the day he was supposed to testify. So they went and had a small meeting in the back. We're gonna get into it. So this is Woody testimony.
First, we're gonna publish 358 Yankee. And looking at 358 Yankee, can you tell the jury, tell the jury which of the two of you is Little D or who you call your son? Which person to the left of you, right of you?
What you mean?
Is that Little D to my right?
This Little D in the picture with me.
Okay. And do you know how long ago you took this picture?
No, I don't.
And we keep saying Little D, your son. Do you know his given name? His real name?
No.
Do you know his real first name?
You said Demikian Garlington.
Okay. And is that the person that you know is Little D?
This Little D right here in the picture with me.
And is that Demikian Garlington?
This Little D right here.
Is that Demikian Garlington?
If that's what his name is, yes.
Okay. Now showing you 380 Yankee. Can you zoom in to the picture?
Damn. I be trying to tell niggas, man, all them photos, man. They going your man. Look at that. Them niggas standing on the block chilling. They ain't thinking that no.
Now looking at 380 Yankee, now is that you sitting on the step in a white t-shirt.
Crazy.
And blue jeans and black and gray sneakers.
Never look at the picture.
And
me and
who's
my
the
homie.
other person you
I
said
ain't
that
in
you
them.
knew in this picture?
The reason
The ugly boy right here.
Okay. And what is that?
I was there.
What is the individual that you pointed to?
I ain't
What's
getting
their
the
name?
pictures.
Coco.
All right.
Can't do that.
And
10
in this
years
picture,
later.
the person behind you with the 30 deep B.
They trained us a long time ago, nigga. Don't stay off them fucking photos, nigga.
I think it's BITXH
photos, nigga.
shirt on. Do you know who that is?
I can't recall who that is.
You cannot recall. Does that look like Demekian or Little D? Does that look like Little D?
The head cut off.
Okay. If you could, can you turn your chair around and look behind you?
What about it?
Does
that look like Little D?
Met in the chambers for him. Him,
I guess.
and the prosecutor.
Okay. Well, is someone you call your son? Does it look like the person you know to be your son?
But he already been sworn in. So they went in back, met with him. I don't know what they met
if
with him
anything,
about.
are you doing with your
Young Thug
in this
lawyer
picture?
finds out about it, right? I'm gonna play that video too. His lawyer finds out about it. That they had a closed chamber
I want to go
meeting,
back to
which he was supposed
358
to be
Yankee.
there, which in turn gets him held in contempt. They try to take his notes and they lock him up. Because he won't disclose how did he find out they had a closed chamber meeting with
What, if
Woody,
anything, are you doing with your hands in
prosecutor,
358
and the
Yankee?
judge.
What you mean?
This case is
What, if
crazy,
anything, does
man.
what you're
This
doing with your
shit
hands
is
symbolize,
crazy.
if anything?
And they doing
Does it
a
mean
lot
anything
of shit, and it's not
Why are you going up a
allowed
bird
in
in
the
this picture?
courtroom. And I don't see why
'Cause I'm
they
from
didn't
Mechanicsville.
judge.
Is that the symbol from Mechanicsville?
Why his
represent a
lawyers
bird.
ain't filed a
And then
motion
what
to
about
have that
Demekian?
still
Are you
removed?
familiar with the hand gesture?
But
that
he ain't playing. He's my lawyers would have did everything and they probably had that nigga removed. Fuck out of here. Probably would have not been playing with him. No way.
Familiar with the hand gesture that Demekian
Reason why I'm
is
able to do
using.
this shit today.
And I'll-
Shout out to them.
Now, I don't know what that for to me.
You don't.
We're gonna play that one too. Or they lock his lawyer.
How is
up.
your relationship with
Crazy.
with Little D today?
On behalf of her.
Meaning?
Do y'all still have the same relationship that you had back in, say, 2015?
No, we don't.
Because he didn't want to testify.
How has it changed?
But he already he been exposed on the video.
I wanted him to lie for me and he wouldn't.
Okay.
But they gave him immunity though.
When was that?
Anything he say on the courtroom, he can't be charged.
Back in the day.
When you say back in the day, what do you
killed 9
mean?
people. Can't charge him.
When the police was accusing me for stuff, I went to Lil D and told him what I wanted him to tell the police.
Oh, wait.
And he wouldn't tell the police that, so I got mad at him.
Okay.
Oh, wait.
And what year are we talking about that this occurred?
I don't know.
Are you speaking about one specific occasion or just multiple times?
No, I'm talking about one specific occasion, however you pronounce it.
And is your testimony that you have not been friends with him since that time?
Now, I have spoken with him, but our friendship ain't been the same.
When you think about your friendship with Demekian and your friendship with Shannon, at this point, who are you closer to, Shannon or Demekian?
Myself.
Okay. But outside of those, I'm speaking specifically about those two individuals, between Shannon and Demekian, at this point, who, if either of them, are you closer to?
I don't understand what you're trying to say.
My video.
You and Demekian that's like your son, right?
Right.
And you said that the two of you, I'm just trying to clarify for Mr. Copeland.
I'll sustain the objection. You can still replace.
You consider Demekian like a son. Is that fair?
No objection. I'll sustain the objection.
Look, he won't even let his objections go through.
Who are you closer to today?
Shit's crazy.
Demekian, Shannon, or neither one of them?
God.
Okay. That's good that you're close to God, but I'm talking about Demikian, Shannon. Who are you closer to today? Demikian, Shannon, or none of them, or neither of them?
I guess neither. I don't know how to answer that.
Back in 2013, 2014, 2015, that's the time frame we're talking about. How close was the relationship between you, Shannon, and Little D?
It was difficult.
You said it was difficult?
Right.
How was it difficult?
You just put 3 years together. So a lot happened within 3 years.
So let's first start with 2013. Describe for the jury your relationship with Demikian, Shannon, and Little D. Let's start with 2013. Tell the jury about your friendship and relationship with those two young men back then.
As in what? Look, I took special ed classes. You got to talk to me in a way that I can understand.
Sure. Back in 2013, were you friends with both Little D and Shannon?
Yes.
Okay. How close were the three of you back in 2013?
Again, my friend was killed. That's when I started embracing Little D.
All right.
In 2013.
When you started embracing Little D, were you and Shannon friends at that time?
Me and Shannon was friends, but me and Shannon was not together on the street as much as friends. We was not together a lot.
Okay. When did you, Little D, and Shannon start hanging together a lot?
20.
Did you, Shannon, and Little D hang out together?
Yes.
When did the three of you start hanging around each other?
The longest I've been out of jail was 2014.
To your knowledge, did Little D and Shannon strike that? How did the three of you all start hanging out together?
I don't know.
Okay. Did you introduce Little D to Shannon?
No.
Did you introduce Shannon to Little D?
No.
Okay. Did Little D and Shannon know each other before they knew you?
I state objection.
Man,
Do
they
you
are
know
checking
they
every
knew each other
lawyer
before
in the
they
damn
knew you?
courtroom.
I don't know.
You don't know.
I don't recall how it started. I just know I started embracing Lil D after DB got killed. Lil D was more a DB friend.
After DB passed, you embraced Little D. Did the two of you start hanging out with Shannon after that?
I just said, how could I say this? Me and Shannon wasn't together in so long to be on the street. So I don't know when all three of us was able to get together. I just know at one point we used to go to the club together.
Did y'all do anything else besides go to the club together?
Yeah.
What?
Objection, Your Honor. May we approach? Sure.
Welcome back. Tim, the SEO manager, was losing a ton of organic traffic to his main competitor.
So we said that you all would hang out. Did you all spend time at each other's homes?
No.
Okay. Did you all spend any time at other people's houses together?
What you mean?
Like, did you all go to other people's houses and spend time at other? Okay. You said you went to the club. Would you all go out to eat together?
Yeah.
Okay. Did the three of you go on any vacations together?
No, we don't do vacations.
Okay. Did you ever take any trips out of town together?
Not that I recall.
Were you familiar with any of Demikion's family? His mom, his
I know his mom.
What about Shannon? Did you know his grandmother or any of his other family members?
No, I didn't.
You have children. Did they have any type of relationship with your children, Little D or Shannon?
No.
Okay.
Not that I know of.
All right. What about you? Did you ever spend time? Let me back up. Did Little D have children?
Ain't no telling.
Okay. To your knowledge, does Little D have children?
Not to my knowledge.
All right. To your knowledge, does Shannon have children?
I think so.
Okay. Have you spent time?
Well, Shannon have children.
Yeah. Have you spent time with his children?
I have.
Okay. Have you taken them to birthday parties?
But my relationship with his children is not through him.
Okay. Who's it through? Their mother?
Yeah.
Okay.
I didn't even want to say it. Let's up some people in the background.
No permission to approach?
You show them to the defense.
Show it to him now, Your Honor. You have to look at this one. This one.
Hold on, let me turn this off so they don't pick nothing up in the background. Wait a minute. Nothing guilty about to end his testimony. Let me see. Here we go.
Mr. Copeland, I want to show you what's been marked as State's Exhibit 355 Yankee. 357 Yankee.
Now these are Instagram photos out here cell phone.
345 Yankee.
They showing them. They don't have any other surveillance. But what they got out their cell
346
phone.
Yankee. 359 Yankee. And 374 Yankee. First, I'm going to start with 345 Yankee. Can you tell me if you recognize anybody in Stacy that was 345 Yankee?
I can't recognize nobody in 345.
Do you see yourself in 345 Yankee?
The picture blurry. I can't recognize nobody in the picture.
Okay. Have it blown up. Okay. We'll come back to 345 Yankee. I'm now showing you what's been marked as State's Exhibit 346 Yankee. Tell me if you recognize Exhibit 346 Yankee.
It's blurry as well.
Okay, so you can't see that. All right.
See, that's how you know they got them out their cell phones.
Looking at 355 Yankee. Tell me if you recognize the individuals in 355 Yankee.
I do.
How do you recognize the people in 355 Yankee?
Because it's me.
And who? Is there anybody else that you know?
Shannon.
Okay. Anyone else?
Yeah, and D.
All right. Your Honor, this time to say like Tennessee Exhibit 355 Yankee into evidence.
Mm.
And objection states 355 Yankees. No objection. All right, states 355 Yankees again.
Now look at Exhibit 357 Yankee. Do you recognize anyone say Exhibit 357 Yankee?
I recognize myself.
Okay. Do you recognize anybody else?
It look like D, but it blurry. I can't tell.
Okay. Anyone else?
Huh?
Anyone else?
Yeah, I can't tell who this is right there.
All right. We'll put that in the blurry pile. We'll get back to that. Next, 359 Yankee. Do you recognize anyone 359 Yankee?
Yep. Me, Shannon, D.
All right. You're right. This time to stay with Tennessee Exhibit 359 Yankee.
And objection states 359 Yankee. All right, hearing none, it's
Thank you, Your Honor. And then last, State Exhibit 374 Yankee. Do you recognize anyone 374 Yankee?
No, it's blurry.
Okay, so that's in the blurry pile. Court's indulgence for one moment.
Yeah.
All right, let's take 10 minutes and then we'll see where we are then. See where the day leads us. All right.
I got a headache.
We'll be in recess 10 minutes.
Pray.
I'm going to take the fifth.
I'm taking the fifth. So,
Thicker, fuller hair starts with Hims. Discover sprays, chews, and serums made.
okay, this one you took the fifth. We're gonna play this.
Your Honor, lays out that it is the state's purview in order to give use immunity, because it's only the state that brings charges in this case. And we have decided that whatever Mr. Copeland says, he will have immunity in this trial and in this proceeding. And that has been the state's decision, and the state can make that decision. And we have so done that pursuant to 24-5-507. And furthermore, Your Honor, if Mr. Copeland does not testify, he could be held in contempt. We had that conversation with him as well, that he could be held in contempt if he does not testify, Your Honor. And so the state would ask that the order that the court has signed be honored, and that Mr. Copeland be compelled to testify and not insert his Fifth Amendment privilege and testify as a witness in this proceeding.
Can I respond, Judge? Yes, you can, Mr. Miller. So, Mr. Melnick, here's the thing. Your client can certainly advance his Fifth Amendment privilege against self-incrimination. I have signed the order under 24-5-507. So I guess have you explained to your client the potential second and third order effects that could occur depending upon his decision?
I have, Judge.
Okay. All right. I guess the only thing to do at this point in time is to bring him in and determine whether or not he would like to make sure he understands.
I understand
where he is under 24-5-507.
He is present in the courtroom, Judge.
Okay.
What he has told me is that he repeatedly told the DA's office that he did not wish to cooperate, did not wish to testify, and wished to exercise his Fifth Amendment privilege. But I can bring him up and have him state that on the record.
Have him see here, sir. No, he doesn't need to be sworn in yet. No. All right, Mr. Copeland, your counsel, Mr. Melnick, have you had an opportunity to talk with him about testifying today?
Yes.
All right. Has the state provided you a letter of immunity or a copy of the order that I have signed directing that they give you use immunity?
Yes.
Do you have a copy of it?
Yes.
All right. Can we see that, please? Can I need 2 copies of it. Actually, 3.
Hey, way to go get your ass.
Not yet, sir. Doesn't apply to you yet, Mr. Steele. But it is going to be part of the record, Mr. Steele. I haven't filed it yet under Odyssey. I don't think it's made the Odyssey system quite yet. So, anyways. Huh?
We have a proposed order.
But I signed the order this morning, though.
I meant the manner in which it will be filed will not be made public.
Okay. All right. Which copy's been given to Mr. Copeland? The order pursuant. All right. All right. Do we have extra copies of that? All right, Mr. Copeland, I'm going to mark this as the next court's exhibit in order.
Ohio, this is your call to action. It's an election year and America's future is at stake. Absentee voting is simple.
Absentee voting, early voting, and election day.
Okay. Mr. Copeland, can you take a look at that order for me, please, sir? All right, let's just go through it right quick, okay? I just want to make sure that you understand where you are and you have your attorney here. And if you have questions of the court or your counsel, you can go ahead and do that, okay? All right? You have to answer yes or no, sir.
All right.
Okay, all right. I'm not trying to trick you. I'm not trying to do anything other than explain this to you, all right?
Okay.
Okay, all right. Mr. Copeland, this order reads basically, the state of Georgia has moved the court pursuant to this particular statute, which is 24-5-507, to compel your testimony. And our district attorney, Ms. Willis, having determined that your testimony is materially as necessary to the public interest. And that is, and if you take a look at the footnote, sir, I'm sure your attorney's probably explained this to you, that she has the purview of determining whether or not your testimony is needed for a particular trial. I don't even have that authority. Your attorney doesn't have that authority. You can't decide that maybe it's not really necessary. She makes that decision. So, and it's in the public interest. So you've been subpoenaed in this case to appear before and give testimony in this particular matter. And state has provided the court sufficient reasons as to why you are necessary as a witness in this case. It appears that you've been properly subpoenaed to appear as a witness in this case, and that your testimony is necessary in the public interest. So that's how we, as a due process, gets you to come to court. I mean, you were noticed as a witness. They've identified you as a witness. They've determined that your testimony is needed. Because of the fact that you have some concerns about what your testimony may indicate or could indicate in the case, and that's something that you and your counsel have talked about, and I'm not certainly going to inquire about that. But in order to potentially deal with anything that may come out of that, the state is basically, knowing that you have a Fifth Amendment privilege, says, okay, we acknowledge that. We're going to give you immunity. And as a result of that, then you have to testify as a result of that. If you don't testify, then I, as the judge in this case, have several remedies. One of those is that I could hold you in contempt and jail you because the way that you get out of that contempt is to just testify. That's the only thing they wanted in this case for you to testify. So your attorneys told me you're going to invoke your Fifth Amendment privilege. Done, said. However, the immunity has been signed. I have a copy of that right now. So you're required to testify. So if you don't testify, the state's probably going to ask me to jail you. And I'm probably going to do that. So I'd like you to go ahead out and talk with your lawyer and tell me what you want to do at that point in time, okay?
Do you need any more time to talk, Mr. Copeland? Okay. What is your desire at this time?
I'm taking the fifth.
Okay, you've taken the fifth, but you've got immunity, but you still want to, are you going to testify? That's the thing.
That's the question.
That's the question on the floor. I've acknowledged the fact you have a Fifth Amendment privilege, but the state's given you immunity, so that overrides that Fifth Amendment privilege. They require you to testify.
Yeah, but the state don't know what they're talking about. So they ask me a question that implicate me, then.
Okay, they can't prosecute you on that. They can't. The order prohibits them from allowing them to use that testimony against you. That's what your lawyer, and I'm not going to get into any of the machinations or intricacies of what may or may not have happened in this case, but Mr. Melnick is a very seasoned criminal defense attorney. I've seen him over the past 2 decades. I'm sure that he's probably given you very, very good advice, but the state can't use that testimony. They can't kind of say, have it both ways, like you testify and then use that against you to indict you and prosecute you. Then we wouldn't have any faith that we need to have people come in and give testimony. So that's why they can't do that. They kind of can't go back on what they're going to tell you, So I signed the order. Now they've asked for immunity. I've signed the order. So basically, whatever you have to tell us, you'll tell us.
Say no more.
Do you wish to testify, Mr. Copeland? Is that no? You have to say no on the record.
Say it again.
Do you wish to testify?
He said I tell him whatever I got to tell him. So I testify.
You will testify.
Yeah.
All right, sir. Okay. What we're going to do in just a second is I'm going to go ahead and I'm going to call for our jurors. We'll formally administer the oath to you, and then the state will ask you some questions, okay? And then you'll be cross-examined at some point in time by potentially some...
My attorney before, because I think I just said the wrong thing.
Sure. I'll tell you what. Why don't you step outside and talk to Mr. Melnick? Come on up, Mr. Copeland. All right, sir. What's your pleasure?
Say what?
I said, what's your pleasure, sir? Do you wish to give testimony? I know you don't want to give testimony in this case, but you've been given immunity in this particular circumstance, use immunity. So are you going to testify?
Yeah.
Okay. All right. All right, sir. Then what we'll do at this point in time is we'll call for our jurors and we'll swear you in, and we'll go ahead and take your testimony. Okay.
All right.
All right.
Your Honor, may I request a sound report?
What is it, Mr. Steele? Does our witness need to be excused? Yeah, sure. Go ahead and stand outside, please. If you wouldn't mind, we'll call you in just a minute. All right. Mr. Copeland has left us. Yes, sir. What's your pleasure?
Well, Your Honor, good morning to everyone. Your Honor, I would like the court to weigh in on this, please. I would like it now. That's why I raised it. But if you do it on a break, that's fine. I mean, whatever you want. But I'm citing to court two cases, if you don't mind. Franklin, which is Franklin, like Donald Franklin Samuel, versus State. It's 166 Georgia Appeal 375. Yes, of course. 166 Georgia Appeal 375. It's in Division 2, 1983. Also Waldrop, which is Waldrip, versus Head, like Bubba Head, and that's 279 Georgia. 826, that's Division 2. It's Roman numeral 2A, capital A. 620 Southeast 2D2. Oh, that's wrong. 829, 2005. And Your Honor, what I'd like you to do is the state has stated today, Ms. Hilton told me this last evening, I don't remember the time, but maybe 6 o'clock, 7 o'clock, something like that. But we had 2 telephone conversations. She said that she's met with Mr. Copeland and other members of the prosecution team under Brady. Ms. Hilton told me that there was one statement, and she emailed that to me and to everyone on the defense side. Your Honor, I don't have any of the other notes. Mr. Copeland met with law enforcement on the January 11th of 2015. So God forbid the killing of Mr. Thomas is at 7:22 approximately January 10th, 2015 by the early morning hours. I'm going to tell you about 4 a.m. Mr. Copeland is on video audio recording with Detective Thorpe the next morning. So it's January 11th, 2015. And he made statements that he knows nothing about anything. Since then, he has made additional at least 5 recorded statements that I'm aware of, and he's made other statements that I have nothing on. Anything that, and he's been inconsistent. So anything that he told the state in this preparation would be inconsistent statements, which is impeachment evidence under Brady. And the state, I presume, will claim work product. That's why Ms. Hilton the notes. But work product of the state is typically not subject to compelled discovery, except to the extent that such notes may be exculpatory and must be disclosed under Brady versus Maryland, which is 373 U.S. 83. Well, that's under Franklin. And then Waldrop versus Head says that work product doctrine gives way to the accused constitutional right to exculpatory and impeaching evidence under Brady. So what I'm asking this honorable court to do, order the state to produce all notes. They had investigated. If they don't want to do that, I ask the court to get a copy of the notes in camera inspection and then meet with us ex parte so we can tell the court what we believe would be inconsistent statements, which is impeachment. That's why I brought it up to the court.
All right.
Your Honor, as I discussed with Mr. Steele last night, I turned over the
statement that I believe was Brady, which was what Mr. Copeland told me about an incident in which there was a theft. And I provided that information to defense counsel. Outside of that, the state doesn't have any notes. And so there's nothing else for what I did turn over. We do have one matter, Your Honor, which would be criminal convictions that I would like to address.
Okay, let's deal with the issue first, the first issue of the notes, okay? Do you have any written notes from your interviews of Mr. Copeland? What Mr. Steele is basically saying is that Mr. Copeland's given a few, he said 5 statements, and that some of those may be inconsistent, which would fall into the category of Brady, or may fall in the category of Brady. So do you have any written notes that you or your team took that arguably would be work product, but that I would need to review to determine whether or not they are on Brady?
We do not have any written notes, Your Honor.
All right, Mr. Steele, then that satisfies that issue in terms of that. If I find out that there's any other additional, I'll change the terms of my consideration on that issue.
Your Honor, and I'll get you the case in a moment because I don't have it at my mind unless someone else does, but oral statements must be reduced to writing if they're Brady by the prosecutor.
Yeah. But I think they're saying to you that the only statement that they have that's Brady is.
In addition to that, in our conversations with Mr. Copeland, he didn't give us any different information than what is contained in the 6 interviews that defense counsel has had since 2022. So there's, outside of this one sentence or this one piece of information which we gave, our conversations were not.
There's nothing. Are you telling me that there's nothing that that needs to be reduced to Brady?
Correct.
Reduced as Brady.
If there was, we would have reduced it and sent it over.
All right. Okay. All right. Let's talk about Melnick. Can you have?
Worry about theft of your mail and packages? Wouldn't it be great if you can manage and read your mail when away on?
All right, Mr. Melnick, I wanted you to be here for the this part of the conversation in regards to your client, because these are prior convictions. Okay. All right.
Your Honor, Mr. Copeland has a total of 11 convictions, Your Honor, prior convictions. However, based on 24-6-609, we believe that only 4 of them will be able to be discussed during the pendency of this case. The state has not received, and if any defense counsel can correct me, any notice that they wanted to use any convictions greater than 10 years old. And so I wanted to put on the record the convictions that are greater than 10 years old. Again, I did not see any notice that any defense counsel intended to use these, so we can
or the state's intended to use any of them,
or the state's intentions to use any of them, so that we could have argument on those. So the convictions that I believe should not come in are as follows: 09 SC 82479, which was a September 1st, 2009.
Four.
That one was for theft by taking.
Okay.
Enter an auto
and other charges. Did he plead to that? Okay. I just want to make sure that he didn't plead to. You know, in all candor, Your Honor, I believe he did plead to giving false info. So for the 09 case, he did plead to giving false information. So they would be able to use that for the limited portion of the fact that he did plead to giving false information.
Yes, that part would be.
That part would be.
Would be.
The next case we have, Your Honor, is 10 SC 87662. And he pled in 2010, but he ended up pleading to a misdemeanor. He pled to misdemeanor theft by receiving. The next is 10 SC 96.
10 SC 96.
938.
Okay.
And that plea was taken on March 7th, 2011. And the charge was aggravated assault and possession of a firearm during the commission of a felony. 110195. He pled to this in August of 2013. And he pled to entering on several counts, misdemeanor criminal trespass, misdemeanor obstruction, misdemeanor theft by taking. And then on that same day, he also pled to 12 SC 113315. He pled to that on August 13, 2013. And there he pled to terroristic threats, aggravated assault, and battery. Then, Your Honor, he also had another case, which was null prost, which was 12 SC 113001. And another case, which was null prost. Excuse me, this was a re-indictment of that 12 SC case. So the number was 120161.
What kind of cases were those now?
Those were, it was a possession of MDMA and possession of marijuana less than an ounce. And the 13 SC was a re-indictment.
All right.
And so we believe the admissible convictions, and I can put that on the record, Your Honor. Would be 15 SC 136794, in which he pled to that in December of 2018. And the charge was theft by receiving stolen property.
Question: would you build a website for a major brand with more than 200 million users?
Testimony.
The next is 20 SC 176851. And he pled on January 25th, 2022.
I'm sorry, so can you repeat that fast?
Sure. The indictment number or the date? 20 SC 176851. You're welcome. And he pled to possession of a vehicle with an altered VIN and misdemeanor obstruction of law enforcement officer. Next is 20 SC 176912. And he pled on January 26, 2022. And he pled to possession of a controlled substance, Schedule 1 or 2, with the intent to distribute. And then last is 22 SC 182134, which he pled to on June 29, 2023.
One more time, what was that last number? I'm sorry.
22 SC 182134. And he pled the possession of a firearm by a convicted felon. And that was on June 29, 2023.
That's the conviction on the gun case.
And you're right, there's also a federal indictment. I do not, but he pled to that federal indictment in 2015. And so that indictment would be right. I'll get you the federal indictment number.
Have you shown these, the non-qualifying and qualifying convictions to defense counsel?
I have not.
All right. Can you let them take a look at it?
Oh, they have. Oh, yeah, we did provide.
We do have, well, we did work well, but we have a disagreement about what's qualified.
What?
Through the court's records. Okay, Mr. Steele says he has it. We did file a motion of intent to impeach with convictions over 10 years old, so we're gonna have to address that. But specifically, two of the convictions that the state says are over 10 years old, I disagree with. And that's because the statute reads from my understanding of the statute, and I think the plain reading of the statute, the clock is from the last incarceration.
Is it either or?
Well, it's the one that's
how's the statute
the
read?
furthest in time. The 10 years has to elapse from the last incarceration. When that comes into play is when probation is revoked. When there's a split sentence, and then probation is revoked. And I can get you the cases. But Your Honor, 12 SC 110195, as well as 12 SC 113315. We would agree that the plea was entered over 10 years ago. However, on the court's records, the probation was revoked on 2/21/15. He was in custody at the time, so he's been incarcerated on those charges. The purpose of the statute is that the person has to maintain a history of lawful behavior to reestablish that they are not essentially a convicted felon. And
Which statute are you talking about? I'm just so I can pull it up. But which one are you talking about?
I don't have the number. The impeachment by prior conviction, 609B. 609B. So, Your Honor, the statute says or release from confinement, whichever is what I was referring to in the statute, the plain language of the statute.
Hang tight, sir.
We're trying to argue what he statute. All right, that's basically over with. Okay. Boom. This is what we want right here.
that easy to make good beats with this kid.
Okay, Mr. Steele, would you take the podium, please, sir?
I said, no, this is what I heard you said. Woody had already pleaded the fifth. So Thug's lawyer found out they had a closed door meeting, the judge, the prosecution, and Woody, about him testifying. He already been placed.
All right.
Yeah.
Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy, but as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well,
but in order, you need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
And he's supposed to be here.
That's why I raised it. It is that serious that we should have been there, and it shouldn't have happened.
Sir, that's a whole separate issue. And that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not. I'm trying.
The issue is how did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get information?
But just listen to what I'm trying to tell you. You're threatening me with contempt.
Privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you. I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not sum and substance, but I'm telling you, I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but that's improper.
Your idea may be wrong, and you're asking me to. Listen, I told you the first time, and I'm not.
Sir, I don't want to hold you in contempt, but this is that serious. Judge, you cannot eavesdrop and get
video
information that was not meant for you to hear at that particular point in time.
Judge, listen. I'll do whatever you want.
Oh, they killed
to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can.
Okay, well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder or Miss Love or Miss Hilton,
or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that is a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking
about? But anyways, I'm not going to have a.
When I got this information,
I'm not going to have any further conversation with you about this. I want to know. The question still remains.
All right,
I want to know who gave you the information.
I'd like to know what information happened outside our presence. That's really it.
You in custody at this point.
I think that the needs to again declare a mistrial based upon.
Okay, and I'm going to deny your. I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside of our presence.
And whenever, yes, would you take the podium, please, sir?
Easy. This is fucking bonkers. This is crap. They hold his lawyer in contempt because he finds out they hold a secret meeting with Woody, who pleads the fifth, who was already sworn in. And as a defense lawyer, I need to be there if you hold
Mr. Steele, before I recess, I asked you, how did you get this information? And it is not covered by work product. Only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy. But
as
you know, Georgia Rule Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have.
They're gonna throw his conviction
1.6.
I know what the rules says, but here's the thing.
Well, I'm just.
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah, and that's why I raise it. It's that serious that we should have been there and it shouldn't have happened.
Sir, that's a whole separate issue, and that's why ex parte conversations are recorded.
Why would it be ex parte?
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this on court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is who?
Bars and restaurants rely on Spectrum Business. With super fast internet and TV, you get an always connected network partner. So your customers always get the best. Get internet as low as $39.99 a month and get a free smart TV. Spectrum Business, made to work.
Don't ever think the judge is on your side, bro. Ever. They always with the Constitution. They with the state at all times. Everything the judge is in your favor.
How did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get information?
But just listen to what I'm trying to tell you. You're threatening me with contempt.
Privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you. I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe. You're asking me, I'm not saying you're ordering, but to give you information, and you're saying it's not sum and substance, but I'm telling you, I can't do that under the bar rule.
All right.
Damn.
And you can think about it and stand on that point, because no, that's not what rule to be. I've not asked you sum and substance of what I asked you how you got it.
You can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have
may
an
be
idea how
wrong.
you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time, and I'm not
Sir,
going to breach that confidence.
I don't want to hold you in contempt, but this is that serious.
Judge,
You cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen, and listen. I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is to me. We need a hearing. And I'm moving for a mistrial. It is my understanding upon information belief.
From whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can
Okay,
talk
well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder or Miss Love or Miss Hilton or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated this information. I'm not going to have any further conversation about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information.
And I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside of our presence.
And whenever, yes, I have an expert.
And I'd like to have it all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
Why?
Okay,
Why
that's for another day.
In the first place, I didn't know about this stuff. Brazy, if you didn't read it, you should read it. It's a material part, a critical part of the case. Okay, it's a material or critical part of the case, and it's an automatic.
That is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn.
He already was sworn.
You did it.
The statement should be heard.
So you
said it supposedly.
Man.
And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind, yeah, but the thing is, I think you got this information.
Critical witness and not telling us.
Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there. Unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
Well,
why aren't we?
that leads to be told. But
right now, we don't know why we were excluded from that.
Mr. Steele,
and I want that
stop.
Just stop. Williams' constitutional right on the Georgia Constitution.
Just stop at this point in time, because
Article 1,
because you've already said that. You've already said
Georgia Constitution, and we.
Madam, Ms. Love?
And I know I said this previously.
Yes, sir.
But we are not accepting any proffer from this law.
Excuse me.
Okay. All right.
To the court. The court has inquired. We have no way of knowing what it is or who it was. Conversation, not only was there ex parte communication between court, but there was communication made, I believe, to a person and his lawyer.
It's been too much. It's been too much. The case taking too long. So he gonna get back on the appeal. He just need to get it on record. So when he files his appeal, it'll be on record.
No, the reason that address that particular what he calls fact and put it out there in the open as if it were true. But we certainly have the right to request ex parte communication. This is a matter that the defendants, this was a matter regarding a civil contempt that the court imposed upon a person for not obeying, read the case that Mr. Steele cited. It does not stand for the proposition he asserts that it does.
You cannot have
and further legal support for our position. We would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting
it's mistrial
gets relayed to the parties, and we concern regarding that. We believe that taking the next set of assertions, I would need to know how that information was made.
So you asking for the judges
to counsels for the defendant. We did not. We will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last 2 days, well, the last 2 work days, because we are extremely concerned. We have observed a number of actions on the parts of a number of people that I am not comfortable stating publicly time, but that would appear to call for being addressed in some other way. So as to Mr. Steele's request, I guess it was for a mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice. And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him
take it off the record
where it was that he obtained the information that was made privy in counsel for this court.
You can't strike it off the record. You can't strike it off.
And regarding Rule 1.6, read 1.6 as standing there. 1.6 in no way shields Mr. Steele's answer that the court requested he give. Rule 1.6 has to do with attorney-client privilege.
That's exactly
and
what
that
you're
is
doing.
Information that Mr. Steele obtained his client regarding whatever matters. I don't know if the information was leaked or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6.
That's a goddamn lie.
If the court would allow me a moment.
All right. That's a lie. Crazy. Crazy, bro. They're gonna try to snap notes from him and everything.
Regarding
and smack the camera away. This is crazy.
Regarding further appropriate remedies, Your Honor, we would ask the court for an opportunity to further look into appropriate remedies for circumstances such as this, apart from what the court has already said, because it's grave when information is leaked from within its chambers regarding a matter that has been requested as ex parte.
Woody told him.
And
that's who told him. It was Woody.
We would ask for the opportunity to present to the
That's
court
told him.
additional
He sent the
appropriate
message
remedies
young
that we
thug
believe are
lawyer and
available.
told him they met in this chamber.
Mr. Adams representing Mr. Steele in the capacity of someone who has been held in contempt.
Right.
Mr. Steele just argued whatever it is that they are trying to argue based on information legally obtained
Okay.
from the court's chamber.
Now, having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
All right.
And frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
Well, I asked him, so I didn't ask you.
Yeah.
So, but I'll leave it at that.
Shit.
Okay.
Y'all just gave this boy overturned conviction. Yep.
What is it, Mr. Sharp?
Y'all just gave this boy an overturned
As you know, I
conviction.
represent
Every
Shannon
lawyer that's
Stillwell.
getting
On
represented
behalf
by
of Shannon
somebody in that courtroom
Stillwell, I
say
am going to be
the same
moving for a
thing.
mistrial.
Damn
First
right.
and foremost.
Every lawyer in that courtroom.
I just want to
gonna
clear
ask
up
the
a
same
few
thing.
things that have been said. Today, we were in court to start till approximately. We were given what the meaning was. Frankly, we kind of remain in the dark. I am not a false accuser, okay? I do not just willy-nilly accuse people of things. So I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple days that are absurd. But I will say, Your Honor, what I do know is just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript and I'm going to ask for the recordings as well, should they exist. But I believe that this meeting with a witness without us present may have made the district attorneys and or Your Honor a witness to this in this case.
Damn right.
A material witness in this
Damn
case.
right.
And finally, Your Honor,
prosecute me.
I'm
You
going
a
to
fucking
ask
witness now.
for as soon as possible, I'm going to ask that these proceedings be halted until we can obtain an accurate final transcript for what occurred where none of the defendants or defense counsel were present for, and also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations, but I do think we need to figure out what happened. We need to be in the know and not in the dark about what happened when a meeting occurs with a witness that has been sworn in. And we're not invited to the party. So those are my requests, Your Honor. I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that's our stance, Your Honor. Thank you.
I've noted your motion for mistrial. It's denied. Okay, same thing. You want the Harvey? Okay, all right. Okay, Mr.
I'm adopting all of the
All right.
They all is. Damn right. Damn right. Every lawyer in that
Okay.
motherfucker. Damn right. All of them.
All right, sir.
Georgia playing a dirty game, bro.
By attorney Douglas Weinstein. We also we were here at the appropriate time. And when the court did come out, we were not made aware that there had even been an communication that was that was on the record, just in the point of just letting the parties know that there had been this particular meeting. I had my suspicions that that was likely what was going on, but I could not reduce that to a fact. When the court came out, the court just got we believe that based upon, again, ex parte, we don't have to know the substance all the time. Just the fact that there was that meeting, Your Honor, would have at least put us on some notice that there was something that was going on even beforehand. I thought that would have been the appropriate move, but nonetheless, Your Honor, I'm asking the court for mistrial. I believe it is appropriate here under these facts and circumstances. Thank you.
All right, motion for mistrial denied. Ms. D. Williams? All right, thank you, madam. Motion's denied. Mr. Garner?
At Purdue Global, access a network of more than 600,000 influential alumni and make your comeback with new industry connections. Achieve more with a name that opens doors.
Okay, so noted. All right. Okay, Mr. Steele, last time. Who told you? All right, Mr. Steele's in custody. Once he's clears the area, we'll go ahead and get started.
He pissed.
If I let them started.
Then he played a
Yeah, we're gonna continue. I'm not caught nothing.
What?
I'm not going to participate in the trial without the stealing.
You don't have that luxury at this point in time, sir. You don't. You don't have that luxury. You don't have that luxury at this point in time. You don't.
Addressing the issue we believe is germane.
Sir, you all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now. Say again?
Respectfully, I will not. I cannot.
Sir, you have to.
Damn right, we ain't going on. You damn right.
You're gonna have to you're gonna have to do the best you can at this point in time.
Damn right.
Because you don't get to extort the court. That's what you're attempting to do at this point in time. Sir, yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly. Sir,
wait, you damn right. You. Hell no, we ain't going on.
As the court, under these particular circumstances, everything will come out as it should. I don't think.
Without, it's already been sworn in.
Sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever this morning that.
Accuracy.
But sir, I don't even know. Your co-counsel. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No,
you can't. It ain't up to you.
It's not, sir. That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully,
we are not respectfully at this point.
Simply accept that there's been no violation. We believe that there has
It
been.
was.
Okay, well then
And now
you
the
made
judge and the prosecutor's
you
a
made
witness.
your.
It
No, we're not
was.
doing that at this point in time. So you'll have a choice to make. All right,
Man,
take
we
Mr.
ain't telling
Steele
you
into custody,
shit.
please.
He pissed. He like, fuck him. Fuck him. Fuck him. Fuck him. He a badass attorney, boy. I salute him. He's a badass motherfucking attorney, boy. He cold. He cold. He took one for his team today. And Woody still testified.
To confer with counsel.
Because he took the Fifth Amendment.
Okay, all
After they
right.
gave him immunity. Georgia, a motherfucker, man. Ooh-wee. Look, he a dog.
May I say one thing, Your Honor?
Yes, sir, you
They
certainly
locked
may.
him up. Come game, bro.
Mr. Williams does not wish to go forward without me being here. You are
You damn
removing
right.
me
We ain't even going
against
without me
his
being
will,
here.
my will. You're taking away his right to counsel.
You damn
And
right.
you're conducting material parts of this trial without me present, and I can't
Fucking
learn
right.
about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.
Cold game, bro. They locked him up. Cold game. And they tried to take
If
his
you
vote.
could imagine your ideal way of working, what would it look like?
Cold game, bro.
Monday.com can make it your reality.
Like I
With
said, like, follow,
Monday.com, every
subscribe,
business,
man.
no matter
We
the
wanna give
industry or
y'all this
size,
credit.
can simply work
And we
better.
out.
Monday.com adapts to every team's needs and connects departments in one unified workspace, giving the entire organization the ability to zoom out, track all moving parts, and make smarter decisions in real time. Get everyone aligned towards the same.
Yeah, man. And that was the content. Yeah. So just go to show. Shout out to Young Thug Lawyer, man. He a dog. He's a dog. You out there in these field, man. You out there in the field. Learn your laws, youngins. Learn your laws. Learn what you can do, what you can't do. Keep a lawyer on speed dial. Keep a bondsman on speed dial. If you're playing out here in this field. Because like you see, the state of Georgia ain't playing no games. They gave that boy immunity. He invoked his Fifth Amendment. They locked him up over the weekend. And then before he took the stand at 8 o'clock, they met with him again in the closed doors chambers. No telling what they promised him again, what they told him again, to get him to go out there to testify, because he testified that day again, fully this time. So no telling what they already gave him immunity on and what other deals they promised him. But he got up there and he took the stand and he testified. They locked Thug's lawyer up. But once the appellate court gets his case and the Supreme Court and all that, they don't overturn it. Georgia just don't want to lose. They don't want to lose. And not too many people pay attention to appeals and all that. So he's going to end up just sliding up out of there. But before that happens, though, they're going to get their conviction. Because they're going to meet with how would they say it? How they said, a material witness, a high material witness in closed doors chambers with the prosecutor, the judge, his lawyer, and him. And the defense ain't there. They want that conviction, bro. My only thing to Thug, if he was gonna play these street games, he should have moved out of Georgia. He should have got clear away from Georgia, but they got so many motherfuckers testifying on him. They ain't even been able to take. It's so crazy that the prosecution, the state done had the floor since this trial started. The defense ain't even got it yet. They calling witness after witness after witness after witness. The defense ain't even got the floor yet. So they ain't even been able to fight yet. The cross-examine, they got to go back, cross-examine every witness. Then they got to bring their own witnesses. So this trial's gonna take almost a year. So, and he already been in jail for 2 years, and this trial been going on for almost 10 months. So, shout out to Thug, man. Him, everybody in there that's going to the box with this situation. Man, it's just crazy. It's crazy, but it's easy to get. I'm telling you, I tell them it's so easy to get in shit, and it's so hard to get out. So, like, follow, subscribe. It's MBR Studios, Money Talks Podcast. Only one giving it to you like this. We be seeing y'all tapping in, watching us. The algorithms be trying to stop us, but we ain't tripping. We gonna keep pushing. So we know we the only ones giving it to y'all like this. Like I said, I don't find so many cases in my life. I know what's going on. So, hey, shout out to Thug, man. Hold your head. Shout out to Lucci. Hold your head. They went after Luch. Luch told the motherfuckers, y'all kiss my ass. They told Luch we'd throw your case out. Luch told them, fuck y'all. I ain't doing none of that. It ain't happening. And he's serving his time. He'll be home in a minute. So shout out to him, man. I just think none of it should have happened. It was all over something. All is all over nothing, man. And they stay in jail, and the shit's still going on. And shit, Fonnie Willis, the one that brought the case, and she ain't been in court one day. So, y'all know what to do, man. Like, follow, subscribe. It's MBR Studios, Money Talks Podcast. Code us in the game. Holla.